the Copyright and Neighboring Rights Amendment Bill 2025.
Honorable members, you recall that last week on Thursday, 12th March 2026, the House stood over the debate on the motion for the second reading of the bill, pending clarifications of the contentious issues arising out of Clause 9 of the bill, which is a gist of this bill. We, as I said before, we had a clarification on that clause. However, I will allow the debate to continue. Then that clarification will be made when we reach committee stage. But I want to reiterate this. Nobody should imagine that we didn't want to make the bill. And it is also not prudent for people to sit wherever they sit and start saying we members of parliament are ignorant. We are not ignorant. We are here to work for the public. The debate is open. Yes, Christine. Yes, procedure.
Right Honorable Speaker, thank you so much. You just mentioned in your communication that yes, indeed the House debated that report and was supposed to proceed on the committee stage. Are we therefore proceeding well when we say that we go back to the debate instead of going straight to the committee stage?
I said we are continuing with the debate. Christine.
Right Honorable Speaker, thank you so much. Actually, it is very important that we continue with the debate for people out there in the public to see and listen to what different thoughts are. Because
Christine, is that in the report?
Right Honorable Speaker, I'm discussing Article 9 of the report.
I have said Article Clause 9 will be discussed when we are at committee stage.
Yes, Right Honorable Speaker. I was building my submission, Right Honorable Speaker. I am saying that based on the report, we needed to profile the different stakeholders. For example, when you look at the upcoming and the already established, the report is not bringing out the difference of the interests of these two groups and the expiry of the consideration of the different interests. Because this did not come out, Right Honorable Speaker, in the report. When the interests have an expiry date, that is a consideration for you for this period of time. Right Honorable Speaker, the freedom, I still emphasize that the freedom of when something is exposed to the public, the freedom of the public to enjoy something produced for the public is also missing. To what extent should the public enjoy what you have put forward, especially when you have put it forward? If, as a right, if you didn't want the public to enjoy at all, then to what extent should the public be given that freedom to enjoy what you have put on table? That is still a question from the report, Right Honorable Speaker. Thank you.
Thank you. Yes. Yes, Attorney General.
Thank you, Right Honorable Speaker. And I thank the Honorable Member for the question. I'll just make this analogy. I manufacture a car for purposes of selling it. But because I manufactured it for purposes of selling it for the public to use, we cannot argue that I should be able to access that car without paying for it. Now, this copyright is that property. It is what the artist has made And he has made it for the purpose of the public using it, but he has made it for the purpose of gaining from it. So this law has provided the instances how you could use it. If you want to enter into an agreement with the artist, you could enter the agreement and the artist could give you time. And there are limits, 20 years, 15 years, all those are provided for in the Act. So the right of the public to use the works of the artist are regulated by the law. It is not that when they produce the music, you are at liberty to use it for your benefit, for your commercial benefit, without them benefiting from it. So yes, it's provided for. If you want to use it, you can agree with them. If you want to sell it, you can also agree with them on how you can sell it. So we need to look at it as the property, that this copyright is the property of the artist, and you would like to use that property. How do you want to use the property?
This is a house. They don't clap. Place.
So yes, the way the law is structured, the way the copyright law is structured, it is alive to the fact that the artist would like to sell that product. But how do they sell that product to the public? That's what the law is trying to regulate.
And Christine, you also have an option. If you do not want to enjoy the product, then you decide not to. But if you want to enjoy, you must be able to pay the owner of the product. You get it, eh? Zach, Kabandeke. Tebandeke.
Thank you, Right Honorable Speaker. Right Honorable Speaker, I happen to be a gospel artist. And I've interacted severely with very many upcoming gospel artists, including the pastors that are ministers over the same. Right Honorable Speaker, I'm not so certain whether all stakeholders were consulted enough to accommodate their input into this bill, and yet it is for public consumption. Right Honorable Speaker, in accordance to Luke chapter 6, verse 38, if permission granted to read it verbally.
Honorable Tebandeke, you're only speculating. There was an advert, which was even paid by Parliament of Uganda, inviting everybody to come and bring their views. And when you look at the report, it's unfortunate that when they read the report, you're not here. It gave all the people who came here. So if somebody missed out, we cannot go and pick somebody from their homes to come and give their views. So we will take the views that were given and consider the bill. We are not going to keep this bill forever. Okay? Honorable members, I put a question that the Copyright and Neighboring Rights Amendment Bill 2025 be read the second time. Those in favor send the contrary nay. The ayes have it.
The Copyright and Neighboring Rights Amendment Bill 2025, Bills Committee stage. Clause 1.
Clause 1, Chair.
Thank you, Madam Chair. Madam Chair, the committee proposes amendments to Clause 1 in the following terms. Clause 1 is amended in paragraph 1A as follows. In the definition of broadcasting, by inserting immediately before the word wireless, the word wire.
Chair, can we stand over clause 1 in case we shall get something else to define?
Fine, in the definition. Thank you.
Clause 2.
Clause 2. Clause 2, I put a question that clause 2 be stands part of the bill. Those in favor say the contrary there. The ayes have it.
Clause 3.
I put a question that clause 3 stands part of the bill. Those in favor say the contrary nay. The ayes have it.
New clause.
New clause.
Madam Chair, we have a new insertion of a new clause immediately after clause 3. In the following terms. The bill is amended by inserting immediately after clause 3 the following. Insertion of section 4A in the Principal Act. The Principal Act is amended by inserting immediately after clause 4 the following. 4A, artificial intelligence work to be protected. Works generated by an artificial intelligence system.
Immediately after clause 3.
Yeah. Immediately after clause 3, which will be 4A. And 4A is the head note is artificial intelligence work to be protected. Works and 4A 1 works to be generated by an artificial intelligence system shall be eligible for copyright protection if the works A has been supervised, directed, or substantially modified by a natural person, and B is original. 4A 2, a developer or user who intends to develop any work using an artificial intelligence system shall, 2A, obtain the consent of the author of the work to be used in training data set, and B, maintain publicly accessible records of the general categories and sources of content used in training data set. 3, 4A3, a developer shall implement technical safeguards to prevent the reproduction of training data and shall provide clear usage guidelines to users to the use of artificial intelligence tools. 4A4, the minister may by statutory instrument A, regulate the use of copyright works in artificial intelligence systems, and B, prescribe the criteria to be applied to works generated using artificial intelligence systems to determine whether the work is original. Justification, Madam Chair, to provide for works which are eligible for copyright protection and the use of copyright material in artificial intelligence systems. 2, to empower the minister to prescribe the criteria to be applied to works generated using artificial intelligence systems to determine whether the work is original. I beg to move, Madam Chair.
AG.
Right, Honorable Speaker and Honorable colleagues, we propose that that provision, that insertion be dropped by the House. Right, Honorable Speaker, AI is a tool. It's a tool used to generate protected work. AI is not in, this act is not intended to regulate tools. For example, a musician uses an organ, a drum, a long drum. This act is not about the tools that you use to generate the works. This act is about the works themselves. So the AI policy is much wider, and government is currently working on AI policy on how to regulate and guide people on its use. But to say that we should attach certain value to how the copyright was made would not be appropriate. We propose that that proposed amendment be dropped.
Honorable Baka, I think what AG is saying is correct.
Madam Chair, considering that you want to allow debate on this, Madam? Considering that, Madam Chair, we have made a recommendation.
Do you have any law on AI?
We have made a recommendation in our report that
No, I'm
government
saying, do you
picks-
have a law that you're referring on AI for
No,
you to
we
borrow?
received the
And in the
submission.
circumstance that you don't have, then just concede.
Yeah, can I just make a statement and conclude, Madam Chair, and then you rule? Madam Chair, first of all, I concur with the Attorney General for now that provisions relating to AI need to be looked into further. And we made a recommendation to that effect, that government should pick interest in AI matters and amend the Corporate Act further. But for now, I concede.
Next.
Clause 4.
I put a question that clause 4 stands part of the bill. Those in favor say aye, the contrary nay. The ayes have it.
Clause 5.
Chair.
Madam Chair, Clause 5, the committee proposes amendment to Clause 5, which is Section 13 of the Principal Act in the following terms. Clause 5 is amended in the paragraph B by substituting for subsection 4 the following. A contract of assignment, license, or transfer to do an act falling within a corporate shall be in writing. Justification: for completeness, to harmonize the provision with the head note by including the assignment and transfer of a contract in the proposed subsection 4. I beg to move.
Thank you. AG.
Right Honourable Speaker, we have no objection to that proposed amendment. The import of it is that if you want to deal with an assignment or a license of the use of any person's copyright, you can only do so by showing that you have a contract in writing. We do concede.
Thank you. I put a question that clause 5 be amended as proposed. Those in favor say aye, the contrary nay. The ayes have it.
Clause 5 as amended.
I put a question that clause 5 as amended stands part of the bill. Those in favor say aye, the contrary nay. The ayes have it.
Clause 6.
Madam Chair, Clause 6, the committee proposes to insert Section 13A and 13B in the Principal Act, and therefore Clause 6 will be amended as follows. By substituting the proposed Section 13A, the following. 13A, reversion of economic rights in copyright to author. 13A1, in a contract of assignment, license, or transfer, there is an implied term that the economic rights in a copyright shall revert to the author. A, upon termination of the contract of assignment or license or transfer. B, upon expiry of the term of the contract of assignment, license, or transfer. C, if the holder of the economic rights in the contract of assignment, license, or transfer becomes insolvent or bankrupt and can no longer meet the contract obligations to the author. D, where the contract of assignment, license, or transfer covers the right of publication, the work goes out of print or becomes unavailable or for a reasonable time. E, 5 years before the expiry of the duration of the protection of the copyright works under this Act, or F, for any other reason as may be prescribed by the Minister by statutory instrument. 13A2, the Minister may by statutory instrument prescribe the procedure of reverting the assignment, license, or transfer of copyright to the author. 13AB, in section 13B1, the proposed paragraphs A and B, by deleting the word effective wherever the word appears in the provision. And in the proposed paragraph B, by inserting immediately after the word technological, wherever the word appears, the word protection. Justification, Madam Chair. The proposed 13A is replaced since the provision as proposed in the bill will frustrate freedom of contract and unlawfully deprives copyright owners the full utilization of their rights. The second justification, to adopt international best practices that allow the reversion of the rights of an author under specific circumstances. The other justification, to empower authors who have assigned their rights in a copyright works for the life of the copyright prior to the commencement of the Copyright and Neighboring Rights Act to claim back their rights 5 years before the statutory protection of the rights, and the amendment proposed in 13B are intended to delete the word effective, since the word is redundant and subjective, and to insert the word protection in order to harmonize the provision with the usage of the word under the World Intellectual Property Framework. I beg to move, Madam Chair.
AJ.
Right Honorable Speaker and Honorable colleagues, the proposed replacement of clause 13A by the committee will not work in the best interest of the author. The purpose of the proposal that has been made by government is that you cannot have a copyright on any person's works for a period longer than 20 years. And that and 5 years before that, the owner of the copyright is at liberty to come and take this property back. What this clause is doing, it is mixing up the consequence of termination with the right for reversion. So what we are discussing here is the right of the author to get their works back after the 20 year, and you cannot have a copyright for say 40 years. It can only be a maximum of 20 years. You can write another contract. But the purpose of this was to ensure that if an author, for example, in year 1, entered into a contract for a long period, which was, say, unfair because of the bargaining power, after some time they can get benefit back of their product. We propose, Right Honourable Speaker and Honourable colleagues, that this proposal be dropped and clause 6 stands as part of the bill as proposed by government. We so submit.
Songo.
I want the Attorney General to guide me on this, and the chair of the committee. Madam Chair, you see, in the copyright law, I compose my song, and after composing my song, a certain man wants to buy my album. Remember, some time back, there was no TikTok, there was no whatever they use on social media. And this man, Kasiwukira, may he so rest in peace, bought my music. But by that time, I never had the capacity to record a video out of my music. But has the right over the song. I don't know whether Attorney General, you are following what I'm saying. Now, because it is my song, I composed it. Now, he paid me, he has been selling my music, I got my money. But now I'm putting in a video. I'm recording a video which I'm also going to sell. I want to say how this musician is protected under that direction. Because he's putting his music on TikTok, he's putting it on YouTube, which were not present at that particular time. But now the advantages he's using to sell and get money, which were not available by the other person who had bought the copyright by that time. Can you help me get that one, in that particular clause?
Honorable Seungu, first of all, I want you to know the heading of the clause: reversal of copyright to an author. So let's discuss according to that. You get it? Eh? We are looking at when do you reverse, how do you reverse. Let's be systematic. Move as per the clause. Okay? I don't want the work to be distorted on the Hansard.
Madam Chair,
are you conceding to what the AG had said?
Yeah. What we seek to achieve is that the reversionary interests of the author are protected. And if you look at the Attorney General's contention, it does not water away that intended purpose, that the reversionary interests of the author are protected. So I concede on that.
I put a question that clause 6 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 7.
Chair.
It's becoming juicy now. Clause 7, Madam Chair, is amended in the following terms. Clause 7 is amended in paragraph B in the proposed paragraph 1 by inserting immediately after the word museum the words for use by a beneficiary person other than for commercial use. Justification: the amendment will protect rights owners' interests by limiting access to their works by beneficiary persons as required in the Marrakesh Treaty to facilitate access to published works by persons who are blind, visually impaired, or otherwise print disabled.
Right Honourable Speaker and Honourable colleagues, the import of the provision in Clause 7, amending Section 14 of the Principal Act, is discussing the fair use of works protected by copyright. The purpose of this provision is to allow the use of copyrights for educational, institutional, library, and that kind of thing, not for commercial purposes. Now, when you say for use by beneficiary person other than for commercial use, you're limiting that to only the beneficiary person. Now, that beneficiary person could only be a person who is a beneficiary through a license, through a contract, and through that kind of introduction. So, we note that we need to protect the rights of owners, and we also need to observe fair use of these products, and that is why Clause 14.2 is introduced. So we propose that the provision in Clause 7, in relation to amendment to Section 14L, be left to read: the work is used in an online learning environment by an education institution, library, archive, or museum, full stop, but not for the beneficiary person or other than for commercial use.
Chair.
Madam Chair, the Attorney General should then explain how you protect access of published works by persons who are blind, visually impaired, or otherwise print disabled. How do you protect them?
Thank you. Chair. Of course, government currently, when we are dealing with our education institution, we take into consideration all the needs of all the persons, even those ones who are visually impaired, those who are impaired in any other way are provided for. So when you say for educational purposes, it is encompassing all the person in the educational
Attorney
space.
General, K protects what is asking about.
Fair enough. I'm
You
satisfied with
read K.
Okay.
K on the bill.
In the bill.
Yes.
Does it?
It does protect.
I concede.
Okay. Attorney General. Attorney General. For avoidance of doubt, just restructure your statement, the amendment.
Right Honourable Speaker, we propose that Clause 7 of the bill stands as it is in the bill currently, and that the proposal made by the committee should not be adopted, because Clause 14 properly caters for all educational purposes for which the copyright could be used. Beg to submit.
Thank you. I put a question that Clause 7 stands part of the bill. Those in favor say on the contrary. The ayes have it.
Clause 8.
Chair.
Madam Chair, the committee proposes amendments to Clause 8, which is amendment of Sections 14 and 14B in the Principal Act in the following terms. Clause 8 is amended in the proposed section 114B2 by inserting immediately after the word found the words identified or is unknown. Justification to harmonize the provision with the definition of the phrase orphan works in clause 1 of the bill.
Right Honorable Speaker, Right Honorable Chair, and honorable colleagues, yes, we do concede that the proposal as made by the committee widens the scope of orphan works and clarifies it as defined in clause 1. We concede to the amendment by the committee.
I put a question that clause 8 be amended as proposed. Those in favor say on the contrary nay. The ayes have it.
Clause 8 as amended.
I put a question that clause 8 as amended stands part of the bill. Those in favor say on the contrary nay. The ayes have it.
Clause 9.
Clause 9. Honorable members, I'm in receipt of a letter from one of the members pursuant to Rule 140, Sub-Rule 4 of the Rules of Procedure. And the member is Honorable Kabanda on the amendment of Clause 9. And I'll invite Honorable Kabanda to move his amendment.
Right Honorable Speaker, thank you so much for allowing me to make some amendments on clause 9. As you have said, I wrote to you on the 9th of March 2026 notifying you about my intentions to move an amendment to clause 9 of the bill pursuant to Rule 140 Sub-Rule 4 of the Rules of Procedure. Right
Yes,
Honorable
go
Speaker,
ahead.
I was unable to submit to the committee because by the time the bill was under consideration, I was away on official duty. Right Honorable Speaker and honorable members, I beg to move the following amendments to clause 9 of this bill. Right Honorable Speaker, I move that clause 9 be substituted for the following. Section 30 of the Principal Act is amended by A. I am by substituting for the proposed subsection 1, where a sound recording or audiovisual fixation published for commercial advertisement purposes or a reproduction of that sound recording or audiovisual fixation is used directly or indirectly by broadcasting or other communication to the public or is publicly performed unless otherwise agreed. An equitable remuneration determined by the minister in consultation with the registrar and relevant stakeholders for the performer or performers and the producer of the sound recording or audiovisual fixation shall be paid by the user to the author for every use of the work. B. By inserting immediately after subsection 1 the following. The remuneration referred to in subsection 1 shall be paid through a payment system established under the National Payment Systems Act. B. 1B. The registrar shall, for purposes of this section, monitor the use of a sound recording or audiovisual fixation for commercial advertisement purposes or for broadcasting or other communication to the public and send periodic reports to the minister. Right Honorable Speaker, 1C, the minister may, in consultation with the registrar and any relevant stakeholders, by statutory instrument prescribe the procedures for collecting, distributing and receiving royalties and other entitlements from use of copyright or neighboring rights. Just to justify, to streamline the procedure for collection, payment and distribution of royalties to the author. I beg to amend.
Thank you, Chair.
Yeah. The committee did not propose any amendment to this clause because this clause, the purpose of the clause was to require any person who uses or entity who uses copyrighted materials for commercial purposes to pay a levy. This will enhance revenues for our creatives. It will expand the industry and it will help energize and enhance the work of our creatives. So that purpose has not been lost in this amendment. I have noticed that the amendment still maintains that purpose. What I've noticed in the amendment is just streamlining who is going to determine the equitable payments, because equitable is subjective. So to avoid ambiguities around the issue of equitable payments, this amendment seems to clear that. It says the minister, in consultation with the Registrar General and stakeholders, the stakeholders being the creatives through their CMOs. And then the other one, I think, was on how payments will be done through a system that is well known to us through the bank, such that money is not, you don't just go to a radio station or an entity and you are given money in a bag. The money should go through a system that is established. So I concur with the amendment. It does not change the substance of the clause. And so as a committee, I think we are okay with it.
Thank you. AJ.
Thank you, Right Honourable Speaker. Right Honourable Speaker, upon receipt of your notification of this amendment, we did have a chance to consider this and even had a chance to discuss with the stakeholders who are available on this. We have no objection to this amendment.
Thank you. I put a question that clause 9 be amended as proposed by Honourable Kabanda, agreed with the chair of the committee and confirmed by the Attorney General. Those in favour say to the contrary, nay. The ayes have it.
Clause 9 as amended.
I put a question that clause 9 as amended stands part of the committee. Those in favour say on the contrary, nay. The ayes have it.
Clause 10.
Clause 10. I put a question that clause 10 stands part of the bill. Those in favour say on the contrary, nay. The ayes have it.
Clause 11.
Madam Chair, clause 11, the committee proposes amendments.
Before you go to clause 11, I can first introduce our guests who are up there. We have Edirisa Kenso Musuza. You're welcome. Karunji Shiva. Pius Palazzo. Joseph Mayanja. Chameleon. Moses Saleh. Martin Moomuza. Michael Kalumba. Lillian Mbabazi. Lord Fred Sevata. Alex Lokuten. Cindy Sanyo. Daniel Kazibwe. Ragadi. Pastor Wilson Bugembe. Pastor, where is Pastor? Martin Musoke. Joanita Kawalia. Matthew Nabwiso, Nathan Magola, Cassandra Richard, Kansime Ann, Annette Nanduja, Aisha Nava Ziwa, Sewanyana Malcolm, Raymond Kaisa, Richard Mugisha, Shine Nyashosh, Okuni Edward, Sulaiman Luanga, Alima Namakula, Muzee Idi Masawa, Ronald Mainja, Charles Musoke, Cheyune Mohammed Habib, Nkaluvo Rona, Lubega Edris, Chachimwa Jen, Agaba Ezra, Exodus, West King, Emrys, Bruno, Kamugisha Abia, Sandy Jafaruk, Muinda Rao, Fanta Busoga, Kabi Fred, and Kironde Vidi. You're all welcome. Join me in welcoming them. We also have our own Hilda man. We also have our own Obangaina. We also have our own we have Balaam. And then we have Orone. Chairman Orone. Chairman and then we have Chairman Kayemba Solo. You're all most welcome and thank you for coming. Silo. We also have Silo. Honorable members, can we finish the bill? In the VIP gallery, we have Honorable Margaret Tilu, a Member of Parliament-elect Amuria. We have Honorable Emmanuel Baira, Blambuli County. We have Honorable Kainza Agnes from Budoda. You have Honorable Wanyoto Godfrey from Budadiri West County. You're all most welcome and thank you for coming. Clause 11.
Clause 11.
Madam Chairperson, Clause 11 is an insertion of Section 39A in the Principal Act. Clause 11 is amended in the proposed Section 39A, 39AA in subsection 2 by substituting for paragraph A the following: A, author 30%. 2, by inserting immediately after the paragraph A the following: performer 30%. B, by inserting immediately after subsection 2 the following new subsections: the remuneration to be paid under subsection 2 shall be computed on the net revenue earned by the person exploiting the works of the author or a performer as collar ringback tone after payment of any applicable taxes. A contract for exploiting the works of the author or performer as collar ringback tone in existence before the commencement of this act shall continue in existence as if the same was made under this act, except that the remuneration under the contract shall be the rate prescribed under subsection 2. Justification, Madam Chair, to assign the author and performer separate entitlements, since each has individual rights in the copyright over collar ringback tones. Second justification, to extend the validity of contracts for collar ringback tones and require the payment of rates prescribed under the bill. Finally, justification to specify for clarity that the remuneration is based on the net revenue after tax. I beg to move.
Thank you. AG.
Thank you, Right Honourable Speaker and Honourable colleagues. We have no objection principally to the amendment as it aligns with government's policy to protect the creatives in the industry. Just Right Honourable Speaker, in line with the proposed amendment clause 9, we propose that the remuneration to be paid under this clause, under clause 11, be paid through the payment system provided for under the NPA Act, National Payment Systems Act.
Consequential amendment.
So I'm proposing that consequent to the amendment in clause 9, we amend clause 11 to include that the payments made under this clause shall be made through the National Payment System as prescribed under the National Payment Systems Act. I beg to submit.
Thank you. I put a question that clause 9 be amended as proposed. Those in favor say on the contrary, nay. Those in favor say on the contrary, nay. The ayes have it.
Clause 11 as amended.
I put a question that clause 11 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 12.
I put a question that clause 12 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 13.
I put a question that clause 13 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 14.
I put a question that clause 14 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 15.
I put a question that clause 15 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 16.
I put a question that clause 16 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 17.
Chair.
Madam Chair, clause 17 is insertion of section 49A in the Principal Act. Clause 17 is amended in the proposed section 49A by substituting for the subsection 4 the following. The registrar shall not issue an order or a notice for blocking, taking down, or obstructing of infringement content unless the owner of the copyright proves that an infringement of copyright works has occurred as required in section 45. Justification to harmonize the proposed subsection 4 with section 45 of the Principal Act, which describes an infringement of copyright and neighboring rights, is deemed to take place. Second justification, the certificate of ownership is not proof of infringement since it does not contain the copyright alleged to have been infringed. The proposed subsection 4 is amended since it has the effect of introducing mandatory registration of copyright works in contravention of the provisions of section 3(1) and 2 of the Principal Act and principles prescribed under the World Intellectual Property Organization framework, which grants blanket protection to any copyright works without any formalities such as registration. I beg to move, Madam Chair.
AG.
All right, Honourable Speaker and Honourable colleagues. We do appreciate the we do appreciate the spirit that the committee raises here. However, a clear reading of the entire clause 49 shows that there is a process that you must undertake before a taking down of the works is concerned. However, I am concerned with the reading which says the registrar shall not issue an order on notice blocking, taking down, obstructing of an infringing content unless the owner of the copyright proves that an infringement of the copyright works has occurred as required by Section 45. Right Honorable Speaker and Honorable colleagues, the exercise of copyright activity is not necessarily one that should go to court, because if the owner of the works comes and says that person is using my work without my permission, the registrar should be at liberty to take that down. But if we start talking about proof, then we are saying we have to first go to court, how long it's going to take in court, and etc. After all, the person who has put up the works, if they have a valid claim over those rights, they can still have them enforced. So I propose that the amendment proposed here, it places an onerous task on the owner of the copyright to prove infringement, whereas all they need to say is that I did not authorize you to use my works. And the provision as we have it here, Right Honorable Speaker and colleagues, I think covers that. I propose that that proposed amendment be dropped and clause 17 of the bill does stand as proposed.
Chair.
Madam Chair, the original clause 17 requires the registrar to do obstruction, take down orders when a copyright owner has presented a certificate of registration. And we are saying that is wrong because a certificate of registration, we have already rejected it earlier. Because this is the creatives, once you have a work that you have produced, your rights accrue upon publication of that work, not registration. So if you leave here registration as a condition for the registrar to take down the works that have been infringed upon, then you are saying the creatives must go and register their works, which you are saying no, they don't have to register their work because that right accrues. As soon as you produce a work, the right accrues, you don't have to register. So the only way out is for the rights owner to go and prove that they are the ones who produced that work, not a certificate of registration.
Right Honorable Speaker.
Can I find out, does one have to register a copyright? No, I am asking, I'm not asking you. I'm asking you.
You can register
Not
a copyright.
Can. You must register.
No. The right. Your
the right,
because
that is okay.
There are rights that accrue upon registration.
Yes.
But whether I've registered or not, I am the copyright holder.
Yes.
Yes.
But
and whether I've registered, Madam Chair,
as a creative.
Madam Chair, and whether I've registered or not, I am protected under the law. Yes. I am protected under the law.
Order.
Right Honorable Chair. The Honorable Member is correct that once a creative produces his work, he has a right to that work. But for you to benefit from the protections provided by the law, you must register. Yes. Because you will find it very difficult to tell someone that they're infringing your rights when they did not know they were your works. So you need to register your rights in order for you to protect yourself under the law.
Because anyone can claim. You must register.
Your right exists by virtue of your right.
Honorable Baka, there is a right by virtue of creation. But for you to protect that right, you must register that creation.
Madam
Yes.
Chair, Madam Chair, I have seen flowers from up. I've seen the purpose, the committee was intending to protect the creatives, but I've seen the flowers for the Attorney General, so I concede.
I put a question that the I put a question that clause 17 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 18.
I put a question that clause 18 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 19.
19, Chair.
Clause 19, there is a proposal by the committee. Clause 19 is amended by deleting paragraph B. Clause 19 is amended by deleting paragraph B. Justification, Madam Chair. The proposed subsection 3 is redundant in light of Section 45 of the Principal Act, which describes when an infringement of copyright and neighboring rights is deemed to take place. The proposed subsection 3 is deleted since it has the effect of introducing mandatory registration of copyright works in contravention of the provisions of Section 3(1) and 2 of the Principal Act and Article 5(2) of the Berne Convention and Article 20 of the World Intellectual Property Organization Performances and Phonographs Treaty, which the bill seeks to domesticate, which prohibit the imposition of formalities on both the enjoyment and enforcement of copyright works.
Eje.
Thank you, Right Honourable Chair. Right Honourable Chair, we propose that subclause 3 remains part of the bill. Subclause 3 as proposed by government is that the adequate evidence referred to in subsection 2 may include a certificate of registration. Right Honourable Speaker, Right Honourable Chair, the import of this provision is that the moment a creative produces a certificate of registration, that is adequate evidence that they are the owner of that copyright from the registrar, the copyright registration. So to remove it, this proposal was being made in line with the proposal to amend clause 16. But since clause 16 did not pass, we propose that clause 3 of the principal bill do stand.
Madam Chair, after what we have agreed upon in the previous clause, which was clause 19, clause 17, clause 19 consequentially has to remain as it was. So I concur with the Attorney General.
I put a question that clause 19 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 19 as amended.
There's no amendment.
Clause 20.
Madam Chair,
Yeah.
clause 20 is on substitution of subsection 56 of the Principal Act. Clause 20 is amended in the proposed section 54 in the following terms. In subsection 1, by substituting for the words a group of persons, the words any 30 or more people. B, in subsection 2, by inserting immediately after paragraph A the following new paragraphs: a copy of articles and rules of the collecting society, a copy of the certificate of incorporation as a company limited by guarantee without share capital issued by the Register of Companies, and C, by substituting for subsection 3 the following. The registrar shall not register any two collecting societies in respect of the same band of rights and category of works. Justification. To group the persons as used in the bill is ambiguous and will force enforcement challenges, since it is not certain as to how many people are required to establish a collecting society. The other justification, Madam Chair, to harmonize the provision with Section 58 of the Act, which require a collecting society to have 30 people as a minimum. To require collecting societies be incorporated by the Register of Companies and regulated by the Register of Copyright in order to separation incorporation of collecting societies, in order to separate incorporations of collecting societies and the regulation of their operations. To require collecting societies to be not for profit organizations, and to restrict the registrar to only register not more than 2 collecting societies for each bundle of rights. I beg to move, Madam Chair.
AG.
Thank you, Right Honorable Chair. Right Honorable Chair and honorable colleagues. The committee proposes to amend clause 20 by inserting immediately after a group of persons any 30 or more people as who intend to operate a collecting society. Right Honorable Speaker and honorable colleagues, this bundle of rights are different. You have musicians, you have artists, you have now new groups called TikTokers, you have YouTubers, you have bloggers, you have all manner of people. And to say that there must be 30 crafts, to say that there must be 30 to create a collecting society for a bundle of rights is wrong. Because that means that if there are only 3 who do that activity, then they can't be paid. So we are saying any group of persons who intend to operate will apply and register, so long as the registrar shall not register more than one group for each bundle of rights. And whether there are 5, 10, 100, that's one bundle of rights, and therefore that proposal will create a challenge for the artists, especially if we want to write a law which is going to surpass time. Things could change. Secondly, Right Honorable Speaker, Right Honorable Chair, the provision as proposed by government is that for you to register, you provide a copy of the Constitution specifying the objects of the society as specified in Section 57. To ask them to provide a copy of the articles and rules of the collecting society, a copy of the certificate of incorporation as a company limited by a guarantee without share capital by a register of companies is duplicity. The moment they are registered and they have their constitution, let us allow them to take the form that they wish to take, depending on the circumstances of their business. So, Right Honorable Speaker, Right Honorable Chair, I propose that clause 20 stands as part of the bill without the amendment as proposed by the committee. I beg to submit.
Chair.
Madam Chair, this morning, while interacting with some members of the creatives in our consultation, this matter came up. Although we didn't discuss it thoroughly, I had an opportunity to discuss it further with some of the members. And their ideas seemed to be in line with what the Attorney General has just said. Number one, that having 2 collective management organizations in one band of rights. For example, if you had, for the musicians, if you had the UPRS and then there's another one, it would be an extra cost to the entities.
Why do you take long to? Please.
So, the speaker is accusing me of taking long to finish. So the short of it is that the Attorney General, the proposals are in line with the creatives that we had this morning discussing this matter, and I concede.
I put a question that clause 20 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 21.
Chair.
Madam Chair, clause 21, the committee has a proposal to amend clause 21 in paragraph C by inserting immediately after the proposed paragraph BA the following. BB, in consultation with its members to prescribe fees for accessing corporate works owned by its members. Justification to enable collection societies set fees for accessing corporate works owned by its members.
AG.
Right Honorable Speaker, Right Honorable Chair, we have no objection. That amendment, it enhances the proprietary rights of the members in those societies. I concede.
Thank you. I put a question that clause 21 be amended as proposed. Those in favor say and the contrary nay. The ayes have it.
Clause 21 as amended.
I put a question that clause 1 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 22.
I put a question that clause 22 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 23.
I put a question that clause 23 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 24.
I put a question that clause 24 stands part of the bill. Those in favor say and the contrary nay. Those in favor say and the contrary nay. The ayes have it.
Clause 25.
I put a question that clause 25 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 26.
I put a question that clause 26 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 27.
I put a question that clause 27 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 28.
I put a question that clause 28 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 29.
I put a question that clause 29 stands part of the bill. Those in favor say and the contrary nay. You have even stopped talking. The ayes have it.
Clause 30.
I put a question that clause 30 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 31.
I put a question that clause 31 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Title.
Clause 1.
Clause 1.
Thank you, Madam Chair. Clause 1, the committee proposes amendments as follows. In paragraph A, 2, in the definition of broadcasting by inserting immediately before the word wireless, the word wire.
Chair, we will approve one by one. One definition at a time. Okay?
Thank you, Right Honorable Chair. Right Honorable Chair, in clause 1, there was a proposed amendment to accessible format, which the committee did not question.
To access what?
Accessible format, format
Okay.
copy.
Yes.
Then we have anonymous work. So the third one is the proposal.
And the third one, the proposal is in the definition of broadcasting by inserting immediately before the word wireless, the word wire or.
Right Honorable Speaker, Right Honorable Chair, we concede to that proposed amendment that wire or wireless widens the definition of broadcasting.
Those in favor say on the contrary nay. The ayes have it. Next.
In 3, in the definition of orphan works, by inserting immediately after the word found, the word or is unknown.
AG.
Right Honorable Speaker, we have no objection to that proposed amendment.
Those in favor say on the contrary, nay. The ayes have it.
And in 3, Madam Chair, in the definition of sound recording, by inserting immediately after the word thereof, the words whether as stand-alone fixation or incorporated or used in other media after the initial fixation.
All right, Honorable Speaker. Sound recordings as provided in the bill as proposed by government are a distinct category of work protected by the copyright. And therefore the addition here distorts that meaning. We propose that the definition of sound recording as proposed by the government bill do stand as part of the bill.
I put a question that this stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Madam Chair, 4, in the definition of circumvent a technological protection measure by inserting the following phrase at the end of the provision, without the authority of the copyright owner.
AG.
All right, Honorable Chair and members, we cannot possibly write a law to allow anyone to circumvent the law. So even the owner cannot be allowed to circumvent the law. So I propose that the provision as stands in the bill does remain.
Chair, concede.
I think the Attorney General has been quite reasonable.
You want to circumvent?
You cannot allow anyone, including the owner, so I concede.
Okay, I put a question. Those in favor say on the contrary, nay. The ayes have it. I will drop it.
5, in his
AI is
by
a
inserting the
consequential.
definitions of inserting the following definition in their appropriate order in the bill. AI, artificial intelligent works,
Drop.
means work generated by an artificial
Drop.
intelligence system through human creative input, direction, and supervision.
Drop it. It collapses. Drop.
The Attorney General will come and make a comment on it. Then
It collapses. It is consequential to the. Yeah, it is consequential.
consequentially. The next one is collecting society, means an organization approved and authorized by the Registrar of Copyright, which has its main object or one of the main objects, the negotiating for collection and distribution of royalties and the granting or licenses in respect or the use or copyright works or neighboring rights.
AG.
Right Honorable Speaker and Honorable colleagues, the Act itself, the body of the Act already determines the object of a collecting society. It is in the body itself. So it is, to define it here like this would conflict with the object already stated in the law. So I propose that this be dropped.
No harm, Madam Chair.
Thank you.
Because
Next. Next. Next.
the provision on AI,
Reprographic coffee.
yeah, the provision on AI is dropped in the amendment, in the definition section.
So next definition. Is that all you have?
Right Honourable Speaker, there was a provision under the definition of derivative works to include works generated by artificial intelligence. That is also consequential amendment that is going to be dropped. It had been proposed by the committee. The committee also proposes a provision for training data set, means the data set including copyright works used to train an artificial intelligence model system. This again is a result of, as per the discussion we had in respect to AI as a tool, we propose that that provision also be dropped.
Okay.
Madam Chair, I missed that page in my report. Been looking for it, I could not see it, but the import of our definition was to make it clearer. So if it, in the view of the Attorney General, the matters are clear, I have no problem. I drop.
Thank you. I put a question that clause 1 be amended as proposed. Those in favor say and the contrary nay. The ayes have it.
Clause 1 as amended.
I put a question that clause 1 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Title.
I put a question that the title stands part of the bill. Those in favor say and to the contrary nay. The ayes have it.
Motion for resumption of the House.
Honorable Minister.
Yes. Right Honorable Speaker and honorable members, I beg to move that the House do resume and the committee of the whole House do report thereto. I beg to move.
Thank you. I put a question that the House does resume and the committee of the whole House reports thereto. Those in favor say and the contrary nay. The ayes have it.
Report of the Committee of the Whole House.
Honorable Minister.
Right Honorable Speaker and honorable members, I beg to report that the committee of the whole House has considered the Copyright and Neighboring Rights Amendment Bill 2025 and passed it with amendments. I beg to move.
Motion for adoption of the report of the Committee of the Whole House.
Honorable Minister.
Right Honorable Speaker and honorable members, I beg to move that the report from the Committee of the whole House be adopted.
I put a question that the report of the Committee of the whole House be adopted by this House. Those in favor say and the contrary nay. The ayes have it.
Bills, third reading. The Copyright and Neighboring Rights Amendment Bill 2025.
Honorable Minister.
Right Honorable Speaker and honorable members, I beg to move that the bill entitled the Copyright and Neighboring Rights Amendment Bill 2025 be read for the third time and do pass.
I put a question that the Copyright and Neighboring Rights Amendment Bill 2025 be read the third time and do pass. Those in favor say the contrary nay. The ayes have it.
A bill for an act titled the Copyright and Neighboring Rights Amendment Act 2026.
title settled and the bill passed. You can now say what you want to say.
Honourable Speaker, it's one of those times that I get to congratulate the House on passing a bill. This bill was incidentally initiated by we on the opposition side through our Shadow Minister for Arts, the Honourable Hilary Chiaga, who is part of the community. Government did take over the bill, and the law does allow, and here we are. Let me say, you know, we pass many bills here, and normally the problem is implementation. So I have seen, and the artists are very excited that the bill has been passed. We are all excited that the bill has been passed. But I hope we are not going to have run-ins when it comes to implementation. That's normally the problem. So the bills gather dust and they're not acted upon. And then the excitement ends up fading. I hope we don't get to that point. That said, Honourable Speaker, the old law of 2006 had regulations of 2010 that came through in 2010. We hope that there will be new regulations to actualize, because now this is an amended bill, so we cannot rely on the 2010 regulations. We hope that there will be regulations that will come through to harmonize and actualize some of the things, because there was still some pettifogging over some clauses and so on, but the regulations help to remedy that. I hope that they will come through soon enough so that then actualizing of this new law gets to happen. With your permission, Right Honourable Speaker, kindly allow a 30-second comment from the Shadow Minister for Arts, who is the initial initiator of this bill.
Honourable.
And he's also part of the community. With your permission, Right Honourable Speaker.
Don't take credit from what you've not done. Honourable.
No, I've already mentioned we initiated and government took over.
Honourable Love, please sit. First of all, I want to thank all the members of Parliament for passing this very important law. I also want to thank you, Honourable Hilary, for the first initiation